I'm Lil Ducky coming through, spitting truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.
Okay, hopefully this is better. I don't know what was going on. All right, so today we are going to be going over Laura Owens has decided to ask the appeals court for a reconsideration. We didn't know if Gingras was going to submit and put in for that, because he said he might not, and he might just go to straight to the Arizona Supreme. But he has decided to do reconsideration first. So that will be it. Let's see what he has to say. It's probably a bunch of nonsense, and I cannot wait for the appeals court to smack him down worse than they did earlier. Like, sir, your arguments are still garbage. Let me share this. Ahoy, Bruce. Let me share this out. I got to send the new link. All right. Let's see. Going live. Here we go. All right. Yeah, let's get to it. All right. So let's put up our little banner here. Okay. Hopefully people can read this. So we've got the Court of Appeals, State of Arizona, Division 2. Owens is the petitioner / appellant versus Clayton Echard, respondent appellee. And so motion for reconsideration by David Gingras. All right. Introduction. Pursuant to Arizona rules, the civil appellate procedure or appeals procedure 22, petitioner Laura Owens respectfully moves for reconsideration of this court's decision dated March 28, 2025. Laura understands reconsideration is rarely granted and is not an appropriate vehicle to rehash arguments previously raised and rejected. At the same time, Rule 22 allows the appellate court to consider whether its decision contained erroneous determinations of fact or law. Well, since they were stating that you had no facts, And based on no law, how can they err or contained erroneous determinations when they found no facts and laws in your appeal based on the case that was in front of them? But sure. So he's going to bring up new stuff. I wonder if they are going to bring up the fact that she dismissed with prejudice, because in the ruling that came down from the appeals court, they said, well, she would still, it was without prejudice and she'd be able to file it again against Clayton. And that wasn't true, which we went over. So I wonder if that's one of the things that they bring about here, because that would be considered new, I guess. But let's see if he actually argues things that maybe Rachel Juarez told him, I don't think you argued that in your appeal brief. All right. Here, the memorandum decision contains erroneous determinations of both fact and law, which directly affect the decision. For that reason, reconsideration is appropriate. Discussion. The structural error analysis misstated Arizona law. In her appellate briefing, citing cases such as Marchese v. Abersold, Kentucky 2017, Laura argued the trial judge violated the due process clause and committed structural error by considering extrajudicial evidence relating to the business hours of Planned Parenthood in Los Angeles. This court rejected Laura's arguments for several reasons. Due to the limited nature of reconsideration requests, Laura will not re-raise the same legal argument this court has already considered. Great. Instead, Laura notes this court's own legal analysis of that point rests on erroneous application of Arizona law, specifically on page 1024 of its decision, or paragraph 24 of its decision. After rejecting Laura's structural error argument, this court explained the law as follows. While a trial court's reliance on extrajudicial information may give rise to a claim of structural or of judicial bias apart from structural error claim, see State v. Emanuel, an appellate court from 1989, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. Stage court trials. Gingras says this statement is incorrect because Gingras is the all-knowing God of law in his brain. I didn't know if y'all were aware of that he is the all-knowing God of law. But if you open your Greek mythology books, you will find a picture of David Gingras as God of all the law. Continuing on with his ridiculousness. It contradicts the cited authority and is not an accurate statement of Arizona law. In fact, the cited authority requires reversal of the lower court's judgment in this case. Okay. The conclusion comes from the first cited State v. Emanuel, 159, Arizona Appellate Court from 1989, which involved a defendant who worked as a legal secretary in the Yuma area. I'm sorry if I'm not pronouncing that correct. The defendant was charged with theft. As the case explains, the victim of theft was a clerk of Yuma County Superior Court. Okay. After accepting a plea, the defendant appeared for sentencing where she asked the judge to disqualify himself, arguing bias. The defendant explained to the judge, I feel that you have a personal disgust and animosity and hatred and maybe dislike for me, and that you are on a personal basis with the victim, which I believe could cause bias. Um, oh, okay. I don't know if it would be for bias. I think maybe. But the thing is that no matter in that case, every judge would, I guess, maybe know that county clerk, but it doesn't mean they have a bias. Maybe a conflict, but I don't know about bias. I mean, they can still put aside that stuff, but let's go on, which I believe could be bias. The judge refused to recuse. In his colloquy with the defendant, the judge explained prior to sentencing he talked privately with other lawyers who knew the defendant, as well as the court clerk, the victim. According to the judge, those ex parte discussions were not prejudicial. Uh, okay. This case that he is citing does not have anything to do with Owens v. Echard. Judge Mata did not go have ex parte communications with Clayton Echard or Woodnick or Deandra or any of them. Like, and she also said, I had these ex parte communications. So she admitted to these ex parte communications, which are not appropriate, even though Laura likes to try to have ex parte communications with judges and everybody else. This case, to me, has nothing to do with Owens v. Echard. There, to me, is no similarity. Yeah. And I don't think they ever asked for Mata to recuse herself, except for after the hearing. He asked for a change of judge after the hearing had already happened, but I don't think he ever asked for a recusal. But she wouldn't have recused herself anyways. Yeah. Let's continue. Let's see how he thinks that these things go together. On the contrary, the judge stated, I did talk to 2 lawyers and I did talk to the clerk. What they told or what the lawyers told me was what I would say is in your favor. Okay. On appeal, the defendant argued that the judge's ex parte communications mandated recusal and entitled her to resentencing before a different judge without any other showing of bias or prejudice required. The Court of Appeals agreed. Where a trial judge personally investigates a defendant's background. Oh my God. He is not. Investigates a defendant's background ex parte prior to sentencing. Must he recuse himself from sentencing? We hold he must. Gingras. Nobody knows if there was ex parte investigation into anything. You have speculation. In this case, the judge admitted to doing independent research and investigating. Judge Mata has not said anything like that. You know why he can't find any law that goes with this case is because this case is unique and one of a kind. Hello, Just Jay. Because there's, to me, no case out there quite like this one. Like, there's plenty of girls out there doing too much and lying. But this is not comparing apples to apples. I agree with the case you're citing that that judge should have recused herself because that should not be happening. And the appellate courts got it right. But what you're saying here is not the same thing as Judge Mata. And the appellate courts are just going to be like, I thought he couldn't get any stupider. When judicial misconduct of this type takes place, Emmanuel did not hold the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. Emmanuel says no such thing. In fact, it says exactly the opposite. Nothing in Emmanuel states prejudice is required or the judge's consideration of extrajudicial evidence is subject to harmless error review. Emmanuel held the opposite. The defendant's sentence was vacated and the matter remanded for resentencing without any other showing or even any discussion of prejudice or bias. The judge's consideration of extrajudicial evidence was standing alone the only proof of bias required. I don't think bias is necessarily the right word. Prejudiced, maybe. I don't think it shows bias. Um, I don't know. Bias for I still don't. The argument of bias, even in the Emmanuel case, I don't think it would prove bias to me because you don't know whether that judge even was asking people in these ex parte communications in order to be in favor of the victim or be in favor of Emmanuel. Like, you don't know which one she was looking for unless she said, "Well, I was looking to try to give you the harshest sentence, so I talked to these people." That would show bias. And just like in the Planned Parenthood Open on Sunday thing, I don't think that you can say it was based on bias because she could have been. She's not like, "Oh, I wanna cook this woman. Let me make sure that this Planned Parenthood is closed on Sunday, and I know she's a liar." Or she could have been investigating to prove that at least one of the things Owens says is true. Like, she could have picked a day it was actually opened. So you don't know whether she was doing it to give Owens some points finally, or if she was doing it to nail her. You can't prove. So how do you say it's biased? You don't know. I don't Jay, I think you need to look for somebody else. Um, but I hear she does like contracts. So if you're a contract kind of guy, Laura may be the one for you. It's not relevant other than the perjuring. Yeah. That's all it does. It isn't relevant, and that's why it's not structural, because whether the answer was yes, it was open or no, it was closed, it doesn't change the case because we still have proof of nothing. All right. Likewise, the other case cited by this court, Stagecoach Trials in the City of Benson, Appellate 2013, does not support the cited premise, i.e., that when judicial misconduct occurs, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep seated favoritism. This misstates the holding of Stagecoach Trials. Okay, so apparently the appellate court just misstates things, or these things misstate things. I don't know, because Gingras is the god of law. Unlike Emmanuel, in this case, Stagecoach Trials or Trails, I keep saying trials, Stagecoach Trails did not involve judicial misconduct. Rather, the sole argument in Stagecoach Trails was the trial judge's rulings were too one-sided. Despite the well-settled rule that bias cannot be established solely by adverse rulings, the presiding judge granted a hearing and allowed the defendant to offer other proof of bias, which it failed to do. As a result, the defendant's bias claimed failed, producing the quote, "This court applied here," out of context. Viewed in full context, the error is clear. Judicial rulings alone do not support a finding of bias or partiality without a showing of an extrajudicial source of bias or a deep seated favoritism. Okay. So, judicial rulings alone do not support a finding of bias or partiality without a showing of extrajudicial source of bias and deep seated favoritism. So, where did you have a showing of extrajudicial source of bias or deep seated favoritism? Did you show that? Because I'm pretty sure that your problem here is that you haven't showed that. Because I call balls and strikes. I am one that if Gingras does something right or makes a good point, or I understand something he's saying, I will give it to him. But he has not made any showings of anything. It just is because they believe it is. Owens has a belief she has been prejudiced. Just like Owens had a belief that she was pregnant with boy-girl twins from a blowy. It is just appeals court is just I hope they laugh at this. The rule has no application here. Laura's structural error argument has never based on judicial rulings alone. Furthermore, Stagecoach Trails did not involve the trial judge conducting ex parte interviews or considering extrajudicial evidence. As such, Stagecoach Trails does not support this court's conclusion that a structural error claim based on a judge's reviewing ex parte evidence requires a separate showing of bias or a deep seated favoritism. The case says no such thing. Bunch of word salad to me. Oop. Go back up. To the extent this court held Emmanuel and or Stagecoach Trails require a showing of prejudice when a judge considers extrajudicial evidence or that such conduct was not established by the evidence in this case. It misstated Arizona law. When a judge considers ex parte evidence, that is the only showing of bias required, as the court held in Emmanuel. Arizona law does not require any further showing of actual prejudice or bias in cases involving this specific type of misconduct which occurred here. The misconduct itself is conclusive proof of bias. No, it is not. Yeah, they're going to be told, they're going to love the fact that he's like, you're wrong about the law. You appellate judges. It it's seriously. And if you have not watched my video on Judge Mata actually having permission to view Gingras's blog and possibly see those comments, you should go watch that. It's in my playlist, but I go over where his blog, where people made comments about Planned Parenthood being closed on Sunday that she could have looked at when reviewing all the motions and all the information at the hearing to make her decision. Because all of that were things that were in front of her. And so she had permission to go look at that because it was in a motion. But you can go check out that video after we're done here, of course. Yeah, the money coming in from her family is crazy. Let's see. Yako, I don't even think he believes it. He doubles down and pretends to be exhausted when he gets caught or ignore it to redirect. He just wants to keep the show going by doubling down. Yeah, and as Rachel Juarez said, "Why do you not find a worthier cause?" Like, she is not the hill to die on. Not even on hump day. Okay, so that is a bunch of blah, blah, blah. Nothing's gonna change the appellate's court mind in Part A. Part B. Reversal is mandatory because the trial court failed to make the required statutory finding to support an award of fees under ARS 25324 or 25809. The court is familiar with the procedural history of this case. Are you? Because you act like you don't know what happened back in August when that is your job. But now you are asking telling the court that they are familiar with the procedural history of the case when you're not even familiar with it. So a full discussion is unnecessary except to note a few basic facts. The case began with a petition to establish paternity filed by Laura on August 1st, 2023. In the form pleading she filed, Laura checked a simple box asking the count to award reasonable parenting time. Laura also submitted a generic pro forma plan proposing joint custody with equal time. Pro forma plan proposing. You need to say that like 5 times fast. So he shows here she wants reasonable parenting time. I tell you what, you know who I would not want reasonable parenting time with? Somebody that ARPed me. Yep. I want that person to have no parenting time. He has no respect. He is the God of law, the all knowing God of law. Yeah. Owens has not learned a thing, and she's never going to take responsibility. Nobody's ever going to make her accountable. Like, we try. Her parents enable her. And if Julie or Rachel Mitchell doesn't do anything, she's allowing it too. She's not holding her accountable. Like, it's just sad. And this crap continues to go on and on. These two pleadings, Laura's pro se petition and generic parenting plan, are the only pleadings ever filed in this case where parenting time issues were raised or discussed in a substantive way. In his pro se response, Clayton Echard denied paternity. As for parenting time, Clayton's response was entirely blank. Yeah, because why does he want to fight paternity or parenting time when there's make believe babies? You don't need a parenting plan for babies that are non-existent. It, ugh. Clayton never submitted a parenting plan of his own. Hardly surprising given that no children were ever born. No, he didn't feel the need to even respond to parenting time because he doesn't need to figure out any parenting time because he's not the father. And even if there were babies, he's still not the father. But there were no babies. So again, he's not the father. I think Chase J. Jones is the father, but that is me. Maybe Tag. She needs to go and have a Rabgen test with Tag and Chase J. Jones. Maybe they would find some DNA matches in there. Oh my God, they're the same people. There is a bunch of familial DNA matching in Chase J. Jones, Tag, and Owens. They found lots of identical DNA. And they're like, see, he didn't put anything. After Clayton retained counsel in mid-December 2023, the first substantive pleading he filed was a request to amend his response to Laura's petition. Actually, no. No. No, you're just a liar. Because let's see. Laura filed August 1st. He's acting like this filing. Let's see here. Let's remove. Oh gosh, what did I? Okay, hold on. He's acting like this filing does not exist. Let's bring this one up. Response to petition to establish paternity, legal decision making, parenting time, child support, information of the other party, his information. He says pregnancy has not been proven, neither has paternity. Party A is unwilling to do a paternity test, therefore paternity is unable to be proven. In A, no proof of children shown, no proof of paternity. No sexual intercourse. Oral sex was performed, but that was all. Despite multiple requests, Party A refuses to take a paternity test. She sent me an email saying she would only take a paternity test if we were to date exclusively. See Exhibit 1. Party A has threatened that she will write defamatory comments about this matter and relate it to the press. Well, she did that. See Exhibit 1. Summary. The entire petition is made up by Party A. There is no proof of paternity upon information received and belief. Party A suffers from mental health issues. I am concerned that she is stalking me. That. Other statements to the court. I deny paternity. He says domestic violence has not occurred in this relationship. He says, based on my knowledge, neither parent has been convicted of a drug offense or driving under the influence of drugs or alcohol in the last 12 months. Not applicable on the child support. Request to the court. Let's see here. I request test and costings, or costs, not costings. Order that a paternity is contested. Party A and Party B be ordered to submit such blood tissue tests may be necessary by the court to establish paternity, and that the other party pay all the costs and expenses of the lawsuit under Arizona law, ARS 25809, including blood tests or other genetic tests, filing each child's birth certificate, attorney's fees, and court costs. Other orders. I, Clayton Echard, am requesting a court-ordered paternity test and that Party A pay all costs. I also request an award of attorney's fees pursuant to ARS 25809. 6 and ARS 12349, as this case is groundless and lacking in merit. We never had sexual intercourse. And then that. So, the fact that he is saying that Clayton didn't put anything anywhere until Woodnick came on is ridiculous. And it is not true. COA? Who is COA with good news? Oh, Court of Appeals. I doubt they said anything good to him. I think he's right. Was pro se for this response or sharing? He means the first thing. So it would have been representation. Thanks, Bruce Chuckles. Court of Appeals. Yeah, thank you, Court of Appeals. It clicked in my brain finally. All right. Let's put this back up. Okay. So when he talks about denied paternity, as for parenting time, Clayton's response was a blank. Clayton never submitted a parenting plan. Hardly surprising, given no children were born. He shows that. But he asked for other things. So this was not to me what he's trying to say here is this was all that was up for debate. And then more came up for debate later when Woodnick joined. Like, he's trying to act like the attorney's fees were not on board, in my opinion, at this point. And they were. I think he just tries to act like they're not because they don't fit his narrative. So after Clayton retained counsel, the first substantive pleading filed was a request to amend response and petition. In the pleading, Clayton sought leave to add a request for Rule 26 sanctions while also withdrawing his request for fees under ARS 25809 and adding a request for fees under 25324. Based on Laura's general unreasonableness without any mention of parenting time. Well, because by at that point, parenting time doesn't need to be considered. But they still want other fees. So he's got motion for leave to amend. I guess crossing that out means that they're withdrawing that too, taking that off. The court award respondent reasonable attorney's fees and costs based on petitioners are reasonable pursuant to ARS 25324. So there you go, Gingras. It's saying, okay, at this point, we had Owens saying she was pregnant. Then we have Clayton denying it and asking for attorney's fees due to her being a lying liar who lies. Then we have Owens or Woodnick coming on once again asking for attorney's fees and non-paternity, saying he was not the father. Then we have and mentioning Rule 26. Then she's like, oh, yeah, I'm not pregnant. And then months and months and months. So we still have attorney's fees. We still have paternity. We do not have parenting time or child support to take care of. But we still have paternity and attorney's fees. So her just not being pregnant doesn't take off everything that the judge was supposed to decide in this case. But Gingras seems to think since Owens was the one to file it, that only what she's asking for is what needs to happen. Like, he's trying to act like Clayton doesn't get a response and can't implement things into the case himself when he can. I don't I don't know if he's allowed to add new junk in the reconsideration. I don't think he is. I think you're supposed to just bring up maybe information that the appeals court got wrong and say, "Hey, you you said this when it's actually this." But he's just trying to say that attorney's fees were not even a thing. And then he thinks that Rule 26 wipes out everything. While parenting time was never litigated because no children were ever born. No, it wasn't because they weren't ever born. It was because they never existed. But the issue of Rule 26 sanctions was litigated extensively and aggressively. Yeah, aggressively by you. Just days after Clayton raised the issue of Rule 26 sanction, Laura retained counsel who apparently had a single phone discussion with Clayton's counsel regarding Rule 26. The next day, on December 28, 2023, Laura invoked the safe harbor provision of Rule 26 by moving to dismiss her petition with prejudice, explaining she was no longer pregnant. So he italicized the with prejudice so that the judge would understand that was like she wasn't going to be able to file it again. Because this is the one thing that I thought that he could put in there. No, it was with prejudice. And y'all made the last ruling that it wasn't with prejudice. But it still doesn't matter because the thing was mute. So whether it was with prejudice or without prejudice, Rule 26 was moot. Yeah, if only the appellate court knew the law like the all-knowing law goddess Gingras. I agree with that statement. Parenting time was effectively litigated by determining non-paternity. Yeah, because if Clayton's not the father or there are no babies, well, then we don't have to deal with paternity or parenting time or child support. So that's taken care of. Check, check. Is Clayton required to go to the funeral for the miscarriage if he's not determined to be the father? Nope. He's not required to go, even if he was. Just Despite invoking the safe harbor of Rule 26, and before Clayton's request to amend his pleading was granted, Clayton filed a motion for Rule 26 sanctions. This filing caused in the parties to spend nearly 4 months aggressively litigating the question of Rule 26 sanctions, but not parenting time, as the issue was moot by then, which eventually concluded when Clayton withdrew his Rule 26 motion on April 3rd, 2024. Yeah, the Rule 26 thing concluded then. But here you are in April of 25 arguing Rule 26. It concluded. Over a year ago, it concluded, and you're still talking about it. But based on your own thing up here, We take this off. We take the Rule 26 off. This 25.324 still needs to be discussed. So everything has not been figured out. And neither has the fetal DNA of paternity. So Rule 26 only crosses out Rule 26. The record is clear. The parties did spend extensive time litigating Rule 26 sanctions, but spent no time litigating parenting time. For that reason, Laura took the position, both in the trial court and in the appeal, that the award of $150,000 of fees and costs must have been made under Rule 26, not ARS 25.324. Just because Owens thinks or takes a position on something doesn't mean it's a realistic position based in facts and reality. Because the award of fees was not made under Rule 26. Yeah, feelings. Facts aren't feelings. Feelings aren't facts. Facts don't care about your feelings. It's always so funny to me when people are like, "You're hurting my feelings by telling the truth, by saying facts." If facts hurt your feelings, the problem is not the facts, it's you. Good Lord, if everything was run by feelings, I'm too logical for the world to run on feelings. I don't care. You spent extensive time litigating Rule 26 sanctions. Nobody else. You. In its memorandum decision, this court rejected Laura's position. Yeah, because it's not based in reality. Concluding that because the trial court expressly awarded fees and costs under ARS 25.324 and 25.415, any discussion of Rule 26 was simply irrelevant and unnecessary. Exactly. Yes, you can be aware of your feelings and others' feelings, but you cannot conflate them. Just like when you're in if there's a murder trial, you cannot convict because you feel bad for the victims. You have to go based on the facts and evidence. You cannot say, well, I feel they're guilty, even though no evidence shows that they're guilty. You cannot run things that way. This aspect of the court's decision was incorrect. Oh, tell the appeals court how they are incorrect. I'm sure they love that. As a matter of law, for a separate reason, the court appears to have overlooked. While this court correctly noted that Clayton generally asked for fees under other authority at various times, including ARS 25.324, and while the court is correct that other statutes like ARS 25.324 were generally mentioned in lower courts post-trial under advisement rulings, this court overlooked the fact that the trial court never made a specific statutory finding required to support an award under ARS 25.324. That fact standing alone requires reversal. See Kent v. Kent, Appellate Division 1, February 25th, 2025. So this is a very new case. Reversing award of fees, husband under ARS 25-324, where wife requested findings which the trial court failed to make. Seriously. You're not even going to give us what that case is about? Really? Um, okay. It's an unpublished opinion. Kent v. Kent. She wanted to dissolve the marriage to a husband, requested findings of fact and conclusions of law regarding all evidentiary hearings. Something about a prenuptial agreement. Husband amended the ruling to award him attorney's fees. Strike. Let's see. Dismissed. Even with motion ordered him detailed amount of fees sought. When husband gave the detail, wife objected and requested specific findings of fact on each issue presented as argument. Court entered a judgment without any finality language. The court did not give specific findings explaining the award. Okay, well, that case, once again, has nothing to do with Mata. Mata put findings in there. She said, I am awarding these under this due to this, and this. And there was a finality order. So this, if Mata just put in here, I'm awarding fees just because, and she didn't put why she was saying that Clayton has earned his fees, then maybe you would have a point here. But that's not what happened. But you just pick a conclusion without actually the case having anything to do with this. No connection. Prior to trial, Laura made timely requests for findings of fact and conclusions of law. Laura's request was clear pursuant to Rule 82A1, Arizona Rules of Family Law and Procedure. Petitioner Laura Owens, Laura or petitioner hereby requests findings of facts and conclusions of law with respect to all submitted for decision in this matter. Because Laura asked for findings, Rule 82A required the trial court to make specific findings on all issues of fact and law, including any fee award, to support an award of fees under ARS 25-324 based on unreasonable conduct. The trial court was required to make specific findings that the fees requested were necessary to the full and proper presentation of the action. ARS 25-324C, emphasis added, the absence of that finding precludes an award of fees under 25-324. The exact issue was discussed by the court in State v. Torres. That case involved a petition by the state seeking to recover fees and costs from a punitive father. After a father conceded paternity, The state was awarded money in attorney's fees under 12,849 in the predecessor to ARS 25,809. Why are we talking about 809? Well, I mean, that was one of the things here too, and 325 or 324. At the time, ARS 12,849 contained language identical to ARS 25,324, permitting an attorney's fees award, deposition costs, and such as other reasonable expenses as the court finds necessary to the full and proper presentation of the action. Based on the necessity requirement, the father and Torres argued fees could not be awarded unless the trial court found the fees were necessary to the full and proper presentation of the action, a finding the trial court did not make. This court agreed with father's argument. The state clearly requires that before an award of the cost and expenses of maintaining any proceeding under this section, the court must find that such expenses were necessary to the full and proper presentation of the action and must consider the financial resources of both parties. The court has made no such finding in this case. Okay. So is he saying that when Mata awarded fees and costs, that because she didn't say that I find all of the fees in the attorney's fees and costs thing that Woodnick submitted were necessary in litigating this case, because she didn't say that or put that on there and cite to law on it that it shouldn't happen? Like, I would like an example of what she is supposed to do. Um, let's see. How to award attorney's fees. Let's see here. Seriously? Okay, yes, she did. Yes, she did put all this in her order. Okay. To award it, courts consider the reasonableness of both parties' position and their financial resources. Mata did that. It may also order the fees if a petition was filed without good faith, lacking factual basis, or for an improper purpose. She found all that. And she put all that. She said, this is why I'm awarding attorney's fees. So what is he talking about? I don't have any idea what he is talking about. Because to me, she made a finding of fact and law. Okay, like, he's making no sense. She said the same is true here. Laura asked the trial court for findings of fact and conclusions of law, but at no time did the court make specific findings that $150,000 in fees claimed by Clayton were necessary to the full and proper presentation of ending parenting time or paternity issues. just as the court held in Torres. That omission mandates reversal of the fee judgment. You know what Woodnick and them took out? They took out the part of the case for the order against harassment because Mata could not make a finding of fact or law or award the attorney's fees for that. So they did not include that. They did include trying to track down all of the nonsense Owens did. That is relevant. To disprove credibility. That is relevant. To depose her and the cost to try to depose her 2 times. To deal with the massive amounts of motions filed by Gingras. This is another stupid argument. Point to me, and as I said, even if he wants to say that the Maricini stuff was not necessary, he should be asking for a recalculation. And if he wants to take that out, but guess what? Everything that would have been taken out and recalculated down and by taking out all the Maricini laptop stuff, you have earned more than that by filing these appeals. This, like, I think she added like $30,000 or $40,000 on top of the $150,000. Now, I don't know if that is added once again in fighting the reconsideration. So she's now up over 200,000 because she just keeps piling on. But anything that would have been reconsidered or lessened by filing this appeal, you've pretty much waived that anyways. I guess it would take down some of it, but not enough. This is ridiculous. Okay. To be sure, in the lower court's post-trial and an advisement ruling here, the court noted purely as a hypothetical matter, fees may be awarded under these if these fees are reasonable and if the court finds they're necessary. Lord does not challenge that general premise of law. Are you sure? Because it seems like you do. But at the time of the lower court's under advisement ruling on June 17th, 2024, the court had no factual basis to determine precisely what amount of fees, if any, were reasonable, or whether the specific fees requested were actually necessary to the disposition of the case. This is so because when URA was issued on June 17, 2024, Clayton had not yet submitted his application for fees. She also said, "You're going to have to submit this and I will review it." Clayton's fee application was not provided to the court till weeks later. Upon receiving Clayton's fee application, Laura raised extensive objections, both in the motion for a new trial and also her objections to Clayton's fee application. Among numerous other arguments, Laura's fee objections specifically reminded the court that the fees could not be awarded absent a finding they were necessary, and here the post-trial minute entry does not contain any findings that any of Clayton's fees or costs were necessary. So because she put it in the original thing of the findings, and when she approved the attorney's fees, she should have also said, "I am awarding these costs again under 25,324 for unreasonableness, bad faith, and such. So since she didn't put it in this order and it was in the original one, that it's not okay. Like, oh my God, he makes my brain hurt. Bombastic. Yes, that's a good one. You know who's not necessary or what's not necessary? This reconsideration. What's unnecessary is Laura continuing to lie and fight this knowing she lied. That's unnecessary. Says rather than addressing Laura's objections and making the required findings, the trial court simply ignored the issue. Thereafter, without Clayton even responding to Laura's objections, on August 16th, 2024, the trial court awarded the fees and costs in the amount of $149,219.76. This was error because neither the original fee judgment nor the amended version found the fees awarded were necessary to the disposition of either Laura's parenting time petition or the establishment petition. Well, I would think that's what I'm thinking, Bruce. Like that the award itself implied necessity because I think had there been when she reviewed it and before she said, "Yep, that looks good," if there was anything that was not necessary in there that she would have said, "This one is not necessary and I'm ordering this." But in reviewing it and approving it, to me is her stamp of saying, "I find all this necessary and there's nothing in here that is extreme that didn't go to the issues." Yes, establishment of the petition. He makes no sense. Right. They were not up for and they agreed to this stuff. Like, it just does not he just does not make sense. Um, Failure to make those findings requires reversal. Lack of findings. The court shall make specific finding concerning the proportions of any award of fees and expenses that are based on consideration of financial resources and that are based on consideration of reasonableness of positions. Well, she looked at financial resources of your client. Once again, McDonald's is always hiring. And, since she has autism, there's a lot of people that are hiring autistic people for diversity reasons. Even though you're a liar, it's she can get a job. She can get a job. She can even get a job working with animals. But if she doesn't have a job, is Quartet Farms out of business now? Did they shut down? Like, did they sell everything? Because if she still works for Quartet Farms, she's not unemployed. Because this court cannot make factual findings in the first instance, it is unnecessary to analyze the issues further. However, it is worth noting the lack of findings that Clayton's fees were necessary to the issue of parenting time is not merely an academic problem. Everything wasn't having to do with parenting time, sir. It had to do with the case in general. Like, he thinks because none of these had to do with parenting times that he shouldn't be awarded anything. Like, once again, it is not based on fact. This is so because while ARS 25324 does permit a party to recover fees necessary for the resolution of parenting time issues, no, that is not what 25324 permits. 25324 permits a party to recover fees necessary for the resolution of the petition. He can say petition or the case for litigation of the case. It actually says proceeding under the proceeding, not for paternity time, but for the entire proceeding. Yeah, it says a court, after considering financial resources from both parties and the reasonableness of positions each party has taken throughout the proceedings, with an S, may order a party to pay reasonable amount to the other party for cost and expense of maintaining or defending any proceeding under this chapter on a request of a party or another court of competent jurisdiction. The court shall make specific findings concerning the proportions of any award of fees and expenses that are based on consideration of financial resources and that are based on consideration of reasonableness of positions. The court may make these findings before, during, and after the issuance of a fee award. And if the court determines that a party filed a petition under just one of the following circumstances, the court shall award reasonable costs and attorney's fees to the other party. If it was filed in bad faith, not grounded in fact or law, and if it was filed for improper purpose. She only needed one of those, and she found all three to award them. For the purpose of this act section, costs and expenses may include attorney's fees, deposition cost, and other reasonable expenses as the court finds necessary to the full and proper presentation of the action. Oh my gosh. He thinks that we're just talking about parenting time now. No, it's for the whole proceeding. Go back and read. He always tells, well, you need to go back and read the case law. You need to go back and read it. Clayton's fee application, extensive time entries, which clearly had nothing whatsoever to do with parenting time, and thus could not have been properly awarded. Well, that's funny that 25,324 doesn't say anything about parenting time whatsoever. For instance, the fee application contains entries for time spent speaking with lawyers for Warner Brothers, presumably having something to do with Clayton's status as a former TV celebrity. Not surprisingly, the trial court never found these fees were necessary to resolve any parenting time issue. Staff with Greg regarding contact from ABC regarding Laura's allegations. Calling with lawyers for Warner Brothers with Woodnick regarding Laura's allegations. call with lawyers from Warner Brothers. You know why? You know why he had to call Warner Brothers? Because she was trying to hit up the media, the press. She has gone through a ton of lawyers, and she found one that was not the sharpest tool in the shed. One that is about as delusional as she is. Um, they had to talk to these things about Laura's allegations. If you wanted clarity on these things, maybe you should have asked. Similarly, the fee application reflects thousands of dollars of time spent on other non-parenting time issues, such as drafting Clayton's motion for Rule 26 sanctions and his later request to withdraw the motion. Yeah, because those are things that were happening in the proceeding of this case. Oh my God, the way he twists things is ridiculous. This is not based in fact or reality or law. To be clear, if Laura had not invoked the safe harbor of Rule 26, Clayton could have sought fees for time spent drafting and researching the Rule 26 motion. But Laura did invoke the safe harbor, and while Clayton had no basis to do so, he filed his Rule 26 motion and then later withdrew it. These are not parenting time issues for which fees could be awarded. The fees weren't awarded due to parenting time. They were rewarded because this whole thing was filed in bad faith. I can't even. Oh my gosh. Trial court could never made a statutory required finding needed to support fees awarded, despite Laura requesting those findings, despite her objecting to any fee award made without such finding. For the reason alone, this court should reconsider its decision to affirm the lower court's fee judgment and should remand this matter for such findings to be made and for further objections to be addressed. That's also a losing argument. So far, he's not going to get what he wants. C, the court also failed to make specific findings as to the amount of fees awarded under ARS 25415. In her merits brief, Laura argued the trial court's award of $150,000 in fees could not be justified under ARS 25415 on the basis that she violated a court order compelling discovery. Laura noted Clayton never sought relief under that statute. Therefore, she never had any chance to explain her side of the issue. She explained her side of the issue on June 10th when she said, "I thought I had a right to privacy. I didn't think I had to turn over my personal stuff, even though we've been telling you to turn over your personal information." That was her excuse. Judge got to hear her excuse. She didn't think she had to. The court dismissed that argument with the terse conclusion. Here the court made such finding, thus it was required to sanction Owens for the cost and reasonable attorney's fees Echard had incurred. Owens does not meaningfully challenge that finding. Again, the court did not err in awarding Echard his costs and reasonable attorney's fees. All right, that ruling, what was that ruling again? 25-415. The court shall sanction a litigant for costs and reasonable attorney's fees incurred by an adverse party if the court finds that the litigant has done any one or more of the following: knowingly presented a false claim. Well, we've got one. Knowingly accused an adverse party of making a false claim under a section or with knowledge that the claim was actually true. Violating a court order compelling disclosure or discovery made under Rule 65 of Arizona Rules of Family Law Procedure, unless the court finds failure to obey the order was substantially justified. If the court makes a finding against any litigant under subsection A of this section, it may also impose additional financial sanctions, which Judge Mata did not impose additional sanctions. Institute civil contempt. She did not do that. Modify legal decision-making or parenting time if that modification would also serve the best interests of the child. A false claim does not mean a claim that is merely unsubstantiated. This section does not prevent the court from awarding costs and attorney's fees for imposing other sanctions if authorized elsewhere by state or federal law. The court shall, not the short can, the court can, the court shall. And in that one, it doesn't say that either party has to ask for that one. On 25-324, it does say that a party needs to ask. But under 25-415, sanctions for litigation misconduct, that is up to the court, not up to the parties. So once again, he has no idea what he's talking about. And I'm not a lawyer. Laura maintains there was no factual basis for the finding that a discovery violation occurred, but even if she is wrong, that does not end the inquiry. Just as the trial court failed to make the findings required by ARS 25-324, identifying which part of fees were attributed to which specific conduct, the trial court also did not make any finding as to the specific amount of fees caused by the purported violations. Because it was just attorney's fees. Like, it'd be different if it was like, okay, here's the attorney's fees, and then I'm going to use 5,000 is going to be a sanction for 25-415. Like, she didn't add any extra. Like, oh my God. She really could have gotten much worse, and Judge Mata didn't award anything other than attorney's fees when Owens could have been sanctioned, held in contempt, all this stuff for this case. But Mata knew that Gingras would become a bigger baby than he already is if she would have awarded anything other than attorney's fees. And she probably was like, you know what? It's not worth the headache. He can get his money and I'm not dealing with anything else. And since she wasn't going to deal with it, she was like, here, Attorney General or DA, y'all do something with this. If this court intended to hold any violations of discovery order under ARS 25-415, however minor, could result in an award of unlimited fees for an entire proceeding without any findings as to the reasonableness of the fees or the direct causal connection to the discovery violation, it should say so. On that issue, Laura notes that while substantial authority, including family law, Rule 82 mandates specific fee-related findings when requested, it appears the only authority interpreting the findings required by ARS 25-415 for discovery order violation is an unpublished ruling. Good God. In this case, the party was sanctioned to $15,000 for inter alia violating a discovery order. On appeal, the sanctioned party argued the trial court did not make findings sufficient to support an award of attorney's fees. The court rejected that argument, but not because 25-415 requires findings of any sort. Rather, the court explained that although the ultimate fee judgment did not contain any findings to support the fee award, a prior ruling did containing such findings. He is wearing on my nerves. Let's see here. Um, let's see what this says. Rulings changed. Courts. Okay, that had to do with something in Puerto Rico. She could sell horses and give the money to Clayton, Greg, and Mike, and Dave, and she could buy me a scone. She could. She could buy everybody a scone. But I don't know why they're saying that she is unemployed. She can't afford crap. She's never been able to afford crap without her parents. She has done nothing on her own. She has done it all off the back of her father, in my opinion. Okay. Rather, the court explained that although the ultimate while certainly obiter dictum, this holding implies an award fee under this for a discovery violation would be improper in an absence of any findings as to the amount and reasonableness of the fees caused by the violation, such is the case here. No, it's not. As noted above, because Clayton did not apply for fees until weeks after the trial, court issued its under advisement ruling. The trial judge had no way of knowing what specific amount of fees, if any, Clayton claimed were caused by the alleged discovery violation. Well, the thing is that we were not allowed to fully litigate the case due to the discovery violation. Like, had she have actually turned over the correct Planned Parenthood information, they would not have had to spend money and time talking to Orange County, San Bernardino County, every county other than Los Angeles, basically. So any time that they spent contacting Planned Parenthood other than Los Angeles or Smile was all money that Owens caused Clayton by the discovery violation. So searching her sonogram stuff was the cost of the discovery violation. I can break that down for you. Maybe I should do that. I will break it down and tell you what is what. Similarly, at the time of trial, Laura had no way of responding to a specific details of Clayton's discovery-related fee claim because those details were not known yet. Well, they weren't ordered yet either, so and you did respond once you did know about them, so whatever. As such, the trial court's UAR contains nothing beyond sheer speculation that Laura's alleged discovery violation may have caused Clayton to incur some fees. If she would have been truthful, I'll put that in air quotes, they wouldn't have had to waste money with all the other stuff if she would have just told him the right thing. That would not surprise me. Like, she is very, very talented at that. She could maybe sell it on Fiverr. Until the court was provided with the actual fee application, it could not have founded and never did find that any of the fees sought or awarded were actually caused by the alleged discovery violation. That error separately mandates reversal and remand. Conclusion: for the reasons stated above, the Court of Appeals should reconsider this decision. Well, they're not going to. They're going to tell you to go pound sand. Certificate of compliance and certificate of service. So he filed it on both sides. Now I don't know if we will see a response from Woodnick on this. Because we did see a response in the appeals court, right? Woodnick did do a response on that. Let's see. Or maybe Woodnick doesn't say anything. I guess not. I guess it's all in Owens, and we don't hear from Clayton or Woodnick at this point anymore. But it's basically a load of crap. And I can't wait for the smackdown because they're going to tell him it's not based in facts and law. It's not based in reality. That is not how any of that stuff is actually used for. The cases he cites have nothing to do with what is happening in this case. Yeah, I just don't know that we ever what is this one? Let's see here. Okay, yeah. So I'm sure that well, hello, all of my bacon people. Um, so I'm guessing Mark is probably going to be the one doing the reconsideration. Um, hello. Hello, all of my Lauren Nighty crew. Um, so Mark will I'm sure be responding. I don't know what that is. Um, which Gingras likes Mark Reisinger. So when that comes out, we will, of course, Marcus has until the 5th to file a reply to the motion. Okay, so he's got a little over. So I'm guessing he basically has 15 days as well or something. Um, which would make sense because you've got weekends and then you've got holidays in there. So he gets to reply. Equality. Mark is the appellate lawyer that is from Woodnick's office that is doing the appeal. Gingras has actually said that he likes Mark and doesn't have a problem with Mark. He has a problem with Woodnick and them. But he actually works at Woodnick Law as well. So he's the one that has been handling the appeal. Yeah. Um all he has to say is I concur with your previous decision, right? I would say it's not based in fact and law, not based in reality. Okay. And I want to bring up, since we're here, let's go ahead and bring up something I haven't gone over yet is Gingras's or Laura Owens doing mm, okay. Where Gingras was saying on Reality Steve, "That's not the Laura I know." Laura's not doing all that. It's all JFC. All JFC. The Laura I know is just trying to move on and do other things with her life. Well, then why is all right. Couldn't finish watching that interview due to time constraints. Yeah, it's really hard to look at, but um, you know, Jinger says it's just all in the past. She doesn't want to deal with this anymore. She's not that same person as she was back then. But here we have her. I keep doing this wrong. Here we have her Why is this not doing her trying to reinstate the protection order against Greg Gillespie. But yeah, she just wants to move on. It's JFC that keeps pushing this. It's so ridiculous. So let's just watch this. If you haven't watched this, it's over on Schnitzel Ninja's channel. I'm going to put it at 1.5 speed because it's a court hearing. And it's just a couple of minutes. And this is an ex parte request. And Greg has until the end of this, I believe, to fight it. Her Medium blogs are just responses, but that's what anyone's content is. He has a double standard. Right. Very true. So let's watch this real quick.
Give me 1 second. You're on the record in FM 2024-05275, Laura Owens and Gregory Gillespie. Will you state your name for the record, please, ma'am?
Laura Owens.
And if you'll raise your right hand, make person straight.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, and I did have a chance to review your petition, and that you indicated that you and the defendant were in a previous romance relationship, essentially. Is that an accurate reflection of the relationship between you?
Yes.
And you've alleged a series of incidents that have taken place early between 2023 and 2024. Is it your testimony the information you provided is true and accurate to the best of your information knowledgeable?
Yes. And the order is up on December the
The information is not true and correct to the best of her knowledge, as she states. It is ridiculous. But this is Laura moving on.
sixth.
Oh, okay.
I'm sorry.
Okay.
Yeah.
And that's okay. You're close enough in time with granted hearing. I do find reasonable cause for not the domestic violence has occurred and been a grant the order to you. The defendant will have no contact with you except your attorney's legal process and court hearings. While I can't specifically address third parties because I don't have any jurisdiction over them, I will put some language in the other findings that no contact means no third party contact or other contact through other means like social media. And then it doesn't necessarily apply to any specific person, so it's really hard for that to be policed. But certainly, if he continues to do that, you want to report each violation.
And what this means is when they say third party contact, it does not mean that they can't say things and talk about things in their life in regards to her. It means that basically Greg can't tell Clayton, hey, Clayton, will you message Owens and say this to her for me? That's what third party contact is. And he can't do it on Instagram or social like Facebook or any of that stuff. Like Greg can't have somebody reach out to Owens. That's she thinks that by putting up an Instagram post is them contacting her. It's not, because they don't tag her on it. They don't even say her name. They're not sending her this video. She goes looking for these videos. Yeah, she really does just walk in like it's Starbucks and just orders things off of the menu.
Okay, I will do that.
I will order him one of your residents against 11440. I'm gonna use the second address listed here. Does he have any reason to go with that address in Scottsdale? Because
Yep.
131. Okay, then I'll include that as a protected location. All right, bear with me while I finalize the order, ma'am, and then I have a few other things to let you know.
Okay.
I wish that lady that was coming into the courtroom was like, "Hey, do you know who this is? She's Gray Gray."
Right now, they're gonna get it finalized, and once it is finished, once they finish getting it logged in, we're gonna email a copy back to you. We can submit everything over to Maricopa County Sheriff's Office. The sheriffs are gonna work to get me served. What we encourage you to do is also print out as many copies of that order as you think you're gonna need. One at home, one at work, one in your purse, one in your car, places you go a lot, have a copy of that order of protection. The reason for that, should the other one expire before this one gets served and there's nothing in place, should we show up at your house and the situation escalates to the point where you need to call.
She doesn't need to make any copies. She will need to make 0 copies, because he is never going to be anywhere she is for her to need to have a copy of this, because she is in no danger. None whatsoever. Except for from herself.
You need to call local law enforcement out. When those officers arrive, you can ask them to serve you with one of your copies.
Oh, okay.
You have to keep in mind that any agency that ends in PD, police department, they are allowed to tell you, no, I will not do your service. There's a whole lot of reasons why they can technically tell you no. So they give you the warning, but realistically, they almost always say yes. So do not hesitate to ask any officer if they're present, and so is the defendant, and they will likely get service done to you.
Okay.
Once he's served, the order will be valid for 2 years from the date of service. At any point during that 2-year period, he can request a hearing to cite the order. If he asks for that hearing, we have to set it within 10 days. So it's really important you keep your contact information up to date with the clerk of court, because we're going to reach out to you whatever we have on file to get you notice of that hearing. If that hearing happens, that hearing is going to be your chance to prove these allegations to be true. So you want to bring all the evidence you have to prove the allegations you made to that hearing. There are now 2 ways you can submit evidence in hearings.
See, I don't like this here. That you only have to prove these allegations to be true if the person contests it. And then within the 10 days of the contesting, then she has to prove they're true. But to get the order, you don't actually have to prove that they're true. So when like Gingras is like, she fought these battles and she won these battles and got these restraining orders and got all this, she didn't do crap. Because Maraschini didn't contest it, so she never had to actually prove it. This one, she has, because Greg hasn't made her prove this. I hope Greg soon contests the DVRO or the order of protection or whatever it is being called. But now, if they contest it, and they can contest it anytime in this 2-year period of the renewal, and if that is the case, then you will have to actually prove this. But right now, we're not asking you to prove it.
Hearings and orders of protection, the old way and the new way. The old way, you were just going to bring 3 copies of anything you plan to present directly to the hearing. Then it will get a copy, the court gets a copy, the 3rd copy is yours to use throughout the hearing. That same rule would apply to any audio or video files you plan to use. If you have any of those, you need them saved externally to a USB drive or CD, something like that. Then you would also need to bring a device to play the audio or video file in court. The new way is more tech savvy. Essentially, when somebody requests a hearing on the order of protection, the clerk of court emails both parties a link to a program called Case Center. If you follow that link, create an account, you can then upload all of your evidence directly into Case Center. You can see the courtroom and the other boxes on the screen, those computers that are on those tables. We use that to pull up Case Center, so everybody's looking at everything that's been uploaded directly in front of them. So it eliminates the need to make copies and things like that. The court does not have a preference on which way you decide to submit evidence. It truly is your comfort level, and then we will work with you however you
It's
got those
very
things in.
tech savvy,
The only
Judge.
other thing we encourage you to look into is safety planning. You can Google safety plans, get a
It's
whole lot of
very
information
good
about
on
them.
computers.
I like to present it really simply to you. To me, safety planning is forward thinking and ways to stay safe. It seems like consistently he's doing a lot of harassing behaviors. A lot of it is online. So it hasn't been direct threatening type behaviors. But just because it hasn't happened before doesn't mean it would never happen. And so we encourage you to look into ways to stay safe and plan for your safety so that you're not caught off guard if you should ever need to get yourself out of a situation.
Okay.
That's everything I have to tell you today. Do you have any questions for me?
No, I really appreciate it.
I do wish you the best of luck, ma'am, and you will have copies of your order in your email here shortly. And thank you so much for your patience in getting on the line.
Oh yeah, no problem at all. Thank you so much.
You're welcome. Have a great day.
Thanks, you too.
Okay. She does not need to come up with ways to stay safe. Like, she needs no plan of staying safe when it comes to Greg Gillespie. None whatsoever. Let me see here. What else is there? Do we have, did we go over? I don't remember if we. Let me see here. What was her reasoning? Like, how he violated this? I don't know if I've actually covered this document. So she mentions that they did an Instagram post that said, "Stop this woman." And it says that it's effectively encouraging third parties to stop me. How does "stop this woman" say her name and harass her? It doesn't. It just doesn't. That is a crock of crap. She said that he publicly leaked private emails and texts. Pretty sure your lawyer did stuff like that too. She accused him of being a Reddit handle because she accuses everybody of being Greg Gillespie. He attended court with the subpoena. And he did it to intimidate and distress me. yeah, it's if y'all haven't read this, I did do a video on this, but um here's the link for that document that they had that hearing for. But like they said, she didn't have to prove any of it. So, all right, guys, let's remember to like this video. You can leave a comment, subscribe, turn the notification bells on. I don't know what that is. And share this video, let people know, and we will keep following this saga because Owens and Gingras won't let it end. JFC would like for it to end because we have other things to do. But thank you for joining me tonight to go over this absurd word salad. It's not going to go anywhere. He's going to lose once again, and then he can continue attempting to file it. I don't think so. I just don't think they're going to take it. They're definitely not going to take it at the U.S. Supreme Court. I don't know how the state Supreme Courts go, but I definitely just don't. The U.S. Supreme Court is most certainly not taking this case. But in David Gingras's law license is still active, so he hasn't been suspended. And yes, ending with this comment, her attorney is a danger to her. And Owens is a danger to herself, I guess, but not really. And now she's going to have to pay up more because they're going to once again award Clayton fees on this reconsideration. So she keeps saying, I'm broke, I'm broke, I'm broke, but she keeps adding to her bill. So there we have it, guys. I will see y'all next time. Bye.
They still don't get it.